Whenever young lawyers or law students hear the term case note or brief note, we assume that we have to make a summary of the case. But it's not like that. Hi budding lawyers, Prasanna Naidu here. In this video, we are going to know how to make a good case note. Before that, I would like to tell you that I make such videos helpful for law students and lawyers every week. So if you're new to the channel, then consider subscribing. A case note is a very essential part of our profession. Along with the summary of the case, it also includes many other things, like our pleadings in the matter, on what issues are we going to fight in the court. There is no standard format for making a case note, so different people may have different ways of making it. Here is a rough format which you can use with your additional changes. Facts of the case. This section contains the facts of the case in a very brief manner. If you are dealing with an appeal case, then summarize the procedural history. Very briefly explain what happened in the lower courts. That is the claim that was made and what the court decided. Put it in a chronological manner. This helps the reader in relating with the manner in which the events took place. Remember that the opposite party will obviously put up the facts in a way which suits them. They may try to misrepresent or even quote the wrong facts. So you have to rely on the annexures to establish facts. In a district court, session court or any other subordinate court, the case is at its root stage. Facts can be disputed over here. But once the lower courts give out a judgment, then you have a reliable fact sheet. Heavy reliance must be placed on a judgment for facts of the case, especially the latest judgment of the highest court which has decided the matter. Also, don't forget to include any contradictory fact or evidence which arose in the judgment. Issues. Set out the issues which were discussed in the case. Remember that there is a difference between a question of law and question of fact. Questions of law address how the law can be applied to the facts of the case. For example, whether hitting someone amounts to battery, while questions of fact address what actually happened. For example, whether there is any evidence to show that the defendant actually hit the victim. You are likely to be interested in questions of law for the purpose of this section. But there may be cases where factual issues may also arise. Prayer. This highlights what you are actually fighting for or fighting against. If the case note is being prepared from the side of the respondents, then it must contain the relief sought by the petitioners. Grounds of the petitioner. This is prepared in a case note from the side of the respondents. Every petition is supported by a lot of grounds of appeal. In this section, you cut through the waste and find out the useful part that you have to attack in the case. Arguments of the petitioner. If you are the petitioner, then based on the grounds in the petition, you prepare your arguments for your matter. Here you examine the law which is in support of your claim and highlight the part which is most relevant to your case. Arguments are nothing but an advancement of your grounds in a detailed manner. Here you examine the law which is in support of your claims and highlight the part which supports your case. Arguments of the respondent. This is very similar to the previous heading. This deals with advancing your counterclaims. You prepare your arguments in a manner in which you show why the grounds of the petitioner must not be accepted. Again, you highlight the law on the matter and show why the petitioner's case does not stand. Now the question arises, how do you do it? You may be having your own way of preparing such notes. Stick to what is comfortable with you. I have just placed some points which will help you be more efficient while making such notes. Notes. Firstly, segregate all the documents. Make a list of all the events, documents and calendar dates of those events. In the list, do mention the details of the documents. Details like its source, from where did you get it and who gave it, registration number if any, type of the copy, original, certified, photocopy, translated, etc. Annotate. Annotating during the first read of your case helps you strike out what is not needed and directly reach to important parts of the case. An annotation in the margin will also refresh the thoughts you had while reading that section. Your markings can be as simple as facts. When you spot an issue, you can simply write down as issue, or You can provide a synopsis in your own words. Highlight. Through highlighter, you can color code, which makes referring to the case even more easier. Try to use a color scheme and stick with it. Highlighters make text stand out, but only when used appropriately. Be careful that you do not highlight everything, or else you'll lose the highlighter's effectiveness. Page numbers. Mention the page numbers referring your main brief, and do ensure that the brief is numbered the same way as the copy with the judge. If you have filed replies, rejoinders, etc., then mention it there. Add sections of the procedures. You can also make such note in the forms for mind map, where you can use images, icons, etc. because it works in a better way for remembering. All this will help you very much when you will read the same file again, which is usually certain. Pencil or pen. Pen would be a better option because this case note made by you may not be only used by you, but also your lawyer colleagues or even your senior. And pencil markings may be very unclear. Hence use pens so that it is easier to read for anyone. If you follow all these tips, you'll be surely able to make a good case note. If you liked the video, then do hit the like button and also share this video with your friends. And yeah, also comment. Do not forget to subscribe to the channel and also press the bell icon so that you will not miss any future videos. We'll see you in the next video. Till then, bye bye.